So thank you everybody for coming to our second session in this series for Trademarks 101, Learning the Basics. We're happy to have Cheryl Overheiser from the Philadelphia Free Library to be talking to us about this. Just some background logistics for today's session. We are going to, it is a listen only format, but there is a Q&A box at the bottom of your window. If you can't see it, look near the top of your screen. You should see an exit full screen button that should be able to get you to see the Q&A button. So if you do have questions throughout, please use that box. We will be going through and answering those during the presentation. If there are questions we are not able to get to based on time or anything like that, it does save those questions so we can make sure we get those answered for you to the best of our ability. So with that, I'm going to, we will also send you the slides and the recording sometime probably either later today or tomorrow at the latest. So you will get everything that we're talking about today. So a little bit about Cheryl. Cheryl has a bachelor's in economics from Bucknell University and a master's in library science from Clarion University. She's worked at the Free Library of Philly since 2013 and was chosen as a fellow at the U.S. Patent and Trademark Office from 2017 to 2018. And she's the president of the Patent and Trademark Resource Center Association, whose mission is to discover the interests, needs, opinions, and goals of the Patent and Trademark Resource Centers, of which the Philadelphia Free Library is one, and to advise the U.S. Patent and Trademark Office in these matters for the benefit of the centers and their users, and to assist the Patent and Trademark Office in planning and implementing appropriate services for those centers, their staffs, and patrons. So with that introduction, Cheryl, if you want to go ahead and take over.
Great. Thank you, Brett, for that really nice introduction. Let's get started. So like Brett said, I'm Cheryl. I'm the Patent and Trademark Librarian who's a library coordinator in the Business Resource and Innovation Center, or BRIC, B-R-I-C, of the Free Library of Philadelphia. I'm also the Philadelphia Patent and Trademark Resource Center representative at the library and a former fellow at the USPTO, like Brett said. Please put the questions in Q&A, and like Brett said, we'll stop periodically to answer them. Okay, as I mentioned in the last slide, the Free Library of Philadelphia is a PTRC, Patent and Trademark Resource Center. What is that? We're one of 83 libraries in the U.S. and its territories designated by the USPTO in Alexandria, Virginia, as a resource for patent and trademark information for the public. The Free Library of Philadelphia has been a PTRC since 1986. Before it was us, it was the Franklin Institute across the Parkway, across Logan Circle. They stopped being a PTRC because they were going to start charging people to enter and use the facilities, including the PTRC, and so they moved it over to the Free Library of Philadelphia. Here's a picture of our beautiful new brick space on the ground floor of Parkway Central Library, where the PTRC and other brick services are located. This used to be stacks, but they renovated it, and it actually turned out better than we ever hoped. And how many things turn out better than you hope? It's a beautiful new space. The PTRC's main focus is on patent and trademark information, but we're also include resources for copyrights and trade secrets. We provide information, but not legal advice, since we're librarians and not attorneys. The BRIC also has services for nonprofits, job seekers, and businesses, so please check us out. We're going to talk about intellectual property, or IP as it is known, which are patents, trademarks, copyrights, and trade secrets, which are protections for what you invent or create. The type of IP you use depends on what you create. So we'll do a brief review for what the 4 types of intellectual property do. Patents protect your inventions. Trademarks protect your business brand, like your brand name, logo, or slogan. Copyrights protect your artistic creations, like songs, poems, books, blogs, photos, paintings, or movies or audios. Trade secrets protect your business secrets, like your secret sauce recipe, customer lists, production methods, and it even can protect inventions if you want. Today, we're going to focus on trademarks, the second type of intellectual property, which protect your brand. They protect your brand name, or logo or slogan that identifies your business. So here are 7 different examples of trademarks. We have the word Rivian up here, which is a trademark for an electric car company that's recently been in the news, and their trademark is just their name at the present time. We have the Golden Arches, which is a trademark for McDonald's, then an upside down Y in the circle for Mercedes, both logos only with no words, and then Burger King and the National Football League trademarks, which have both words and logos, and the slogan Pat's King of Steaks, which is a slogan for Pat's Steaks in South Philly, which is currently my husband's favorite cheesesteak place. And finally, Coca-Cola with its distinctive script and red lettering. Some trademarks are words only, some have no words, and some have both. All are trademarks. Okay, here's a definition, which can sometimes be boring, but are necessary to define trademarks. A trademark is generally a word, phrase, symbol, or design, or a combination thereof, that identifies and distinguishes the source of the goods or services of one party from those of the others. So this is, trademarks are something to protect you as a business owner, but also to protect the public. There are some unusual trademarks like sound or scent trademarks. One example of that is the roaring lion sound for that's registered for MGM. So if you go to the movies, you'll recognize the lion with its roaring sound, and the roaring sound is a registered trademark. The most common reason for a trademark to be refused registration is a likelihood of confusion. A likelihood of confusion exists when both the trademarks are similar, and 2, the goods and services of the parties are related, such that the consumers would mistakenly believe they come from the same source. So I'll explain more about this in a bit. Okay. Unlike patents, which only come from the USPTO, there are 3 types of trademarks from different sources with different coverages. There's common law trademarks, state trademarks, and federal. They can be renewed, unlike patents, which cannot. Do you have to get a trademark? No, it's strictly up to you whether or not to register your trademark. Okay, as we mentioned in the last slide, the first type of trademark is the common law trademark. A common law trademark is a do-it-yourselfer and is available immediately. You just start using it. It's cheap and easy. Here are some pros and cons of the common law trademark laid out more specifically. The pros, like we mentioned, it's cheap, easy, free, and do it yourself. The cons are, with a common law trademark, you could be infringing on someone else's trademark without knowing it, and they could send you a cease and desist letter and tell you you must stop using it immediately. As a result, you might have to rebrand your company, which would cost you money, and it's possible that the owner of the registered trademark might also ask you for money damages. Even if that doesn't happen, your business could get stuck staying small with a common law trademark. Say, for example, you were selling in a small geographic area and someone else gets a similar trademark for related goods and services on the federal level, which gives them protection throughout the US and its territories. Even if you were using your common law trademark first, you might get stuck staying in your small geographic area and not be able to expand. As you see, the little TM in the upper right corner of the trademark, that's what you can use for common law trademark rights. You can just put it up there. You can put it above, in the middle, or down below. That means you're claiming trademark rights, and you can use that if you're using a common law trademark. So it just kind of scares people off. I'm using this as a trademark, okay? So maybe they'll think twice before trying to use the same trademark. Okay, the second type of trademark is a state trademark, where you get protection at the state level. This is available in all 50 states. You can see the hyperlink where you can locate the agency that registers trademarks in your state. They're generally cheaper than federal trademarks, but not as powerful. The cost varies from $10 to $50, and they last anywhere from 5 to 10 years. So in Pennsylvania, it's $50 for 5 years at present, but it varies from state to state. Just note, the trademark may not cover the entire state in a federal trademark dispute. You can also use the trademark designation on your state registered trademark. Okay, here we have the federal trademark, which is the most powerful type of trademark. It's good in the US and its territories. It lasts 10 years and can be renewed, as can other types of trademarks. You can see here that there's an R in the circle that you can use when you're granted a federal trademark. The cost starts at $250, and the federal trademark cost is based on what you're selling. If you're selling goods and services in 2 different classes, it would be $250 times 2. You can get the lower $250 cost as opposed to the $350 cost if you fulfill certain requirements, such as paying the fees up front, filling out the application form completely, agreeing to correspond via email as opposed to snail mail, and using an existing class of goods and services. Example, if two different classes of goods and services are, say somebody has a beauty salon and they do hair, then they decide they want to sell their own hair care products using that trademark, they would have to pay another $250 for that. So that would be $500 to apply for both of them. Okay. To get a federal trademark, you must be using your trademark in commerce or have an intent to use it in commerce. Use in commerce means selling or shipping your product or service across state lines. You also must provide a specimen of use, such as a picture of your product or a link to your working websites. And you have to provide a specimen for each class of goods and services. If you're not yet using your trademark in commerce, you can file for an intent to use basis, which is good for up to 3 years, but it will cost more. It generally takes 9 to 12 months to receive your federal trademark, okay? Here is a really helpful brochure about federal trademarks. We used to have it in print form, but now they went to online only, which is actually a good thing because they can update it frequently. And I would really recommend reading this if you're interested in getting a federal trademark. I'm going to click on it so you can follow the link. It looks just like it did in print form, but it's now online. It has a lot of really good information about, we're going to talk about this, domain names, business names, and trademarks, likelihood of confusion, some examples of conflicting trademarks, strong versus weak. It's just a really good resource, and I would highly recommend reading it if you're interested in getting a federal trademark. All right. Also, the USPTO does a really amazing job with the trademark videos. They have 3 different sets at uspto.gov that walks you through really every part of the application process. So they do an amazing job, and so you can click on these links when you get the slides and take a look at some of the really great information that they have for people applying for federal trademarks. Okay. Remember when I said that the likelihood of confusion was the most common reason for a trademark application to be refused? That's because before you apply, it's a good reason to search for existing trademarks, because unfortunately, you will not get a refund if the USPTO does not register your trademark. Currently, about 60% of federal trademark applications are approved, but that means 40% are not, and those people won't get their money back. So it behooves you to do a search, to become aware of what's out there, to gauge your chances of actually getting a registered trademark. You will look for existing trademarks that are similar in SAM, which means sound, appearance, and meaning. Okay, say this first trademark, T-Markey, is registered to sell hats. And then someone else comes along and wants to use T. Markey to sell shirts and pants. These two look completely different, but they sound the same, T. Markey and T. Markey. Plus, hats and shirts and pants are related goods and services. So what are related goods and services? They're things that are often sold in the same place. Okay, this next one, say T. Markey was registered to sell banking services, and someone else came along with T. Markley and wanted to their business to be mortgage lending services. So even though this one is spelled differently, this one has an L. Because they look the same, and banking services and mortgage lending services are related goods and services, this T. Markley would likely be refused to be registered on the Federal Register. You also have to think about the meaning, and that means meaning in foreign languages. Say someone registered Gatto to sell t-shirts and pants, and someone else wanted to use cat for online retail store services featuring clothing. Because gato means cat in Spanish, cat selling the online clothing would probably be refused registration for likelihood of confusion. So you have to look at both SAM, sound, appearance, meaning, and related goods and services. And if they're similar in SAM and related goods and services, you likely will be refused registration. Okay. Conversely, the exact same trademark can coexist with another trademark if the goods and services are different. So here's an example using the federal trademark Acura. Okay, because the goods and services are so different, these federal trademarks for Acura can coexist. Okay, the Honda Motor Company's Acura automobile, the Acura pen from the Idea International Company, and the Acura lab equipment from Sikorex Corporation are very different goods and services and unlikely to cause confusion, even though they're spelled exactly the same. So they can all coexist because there's an unlikelihood of confusion. So, you know, you probably wouldn't walk into a Honda dealership and expect to buy lab equipment. That's why they can coexist. And even though they're spelled exactly the same, it works for a federal trademark. Okay. There are two different federal application forms for trademarks, the standard and the special form application. So this is separate from the 250 and 350. This is something else you have to decide whether to apply for a standard or special form trademark. The standard application is used when your trademark is only words, letters, or numbers, okay? This can give you broader protection than the special form application. Once you get your standard trademark registered, you can add logos and colors to your trademark. You must use the special form application if your trademark includes a design or logo alone or with wording, or if a particular style of lettering or color is important. Once you combine your name, logo, and or a slogan in one special form application, they must always be used together. So here's an example. Here's Shell from the Shell company. And because it's a logo alone with no wording, you would have to apply for a special form on the special form application. Here's Lehigh University with this logo. So they would be required, if they wanted this registered, for a special form application. This one, the CF Martin company, if they applied for a special form mark, it would just be the words, and then they could later add the curvature if they wanted and the special script and establish 1833. If this company wanted to lock in this trademark just exactly as it is, they would have to do the special form. And here is the Just Born company. If they wanted to do Just Born with none of the colors or the background or quality confections, they would do just born. But if they wanted to lock in all these features with the colors and the distinctive bee and quality confections, they would have to use the special form. Okay.
Cheryl,
Yes.
there's one question that someone is asking: is the price the same for these two forms?
Yes.
Okay.
Yes. It just depends on you know, what is in yours, and if you use a special form mark, it will be locked in for that. But you know, if you want a logo just like this with no words, you have to use it. Or you know, if you want like this one, Lehigh University, if they just wanted Lehigh University, they could do a standard application and then add this stuff later, the brown background and the logo. But if they wanted all this together in this form, they would do a special form application.
Great. Thank you.
Okay, good question. Okay, it's easier to get a trademark if your trademark is distinctive. The USPTO Principal Register over here offers the most protection. The strongest protection is on the Principal Register. Trademarks on the Principal Register are distinctive, meaning they're coined or fanciful, which means made up names like Xerox and Kodak are familiar to us now, but they were made up names. They're easier to get trademark protection, but also your marketing people are going to have to work a little bit harder because it's not apparent what they're actually selling. Arbitrary meaning, which is still in the Principal Register, means you take a word that doesn't have really much to do with your product and put it together like Apple did for computers. Or say if I want to have my own sneaker line and call it ketchup, that would be arbitrary and easier to get trademark protection on it. Suggestive means suggesting something about the product, such as ever ready. Batteries, meaning the battery will always be ready when you need it when the power goes out. If your trademark is generic, over here, it says exactly what the product is, or if it's merely descriptive, including surnames and geographic names, your trademark could be refused registration or be registered on the supplemental register with less rights. Trademarks that were originally on the supplemental register in the past, like McDonald's and honey baked ham, can acquire distinctiveness over time, generally about 5 years, and then apply to be on the Principal Register. Okay, so surnames, things that are primarily surnames, are frowned upon by the USPTO to be on the distinctive register, and that's what happened with McDonald's. Because it's primarily a surname, they had to be on the supplemental register, and then after 5 years, they showed that they had acquired distinctiveness. People got to know them as selling hamburgers, and then they were able to move to the Principal Register. Also, things that are merely descriptive, like honey baked ham, it just says exactly what it is. It's ham baked with honey. So they were in the same boat. They had to have registration on the supplemental register with less rights, but after 5 years, they acquired distinctiveness and moved to the Principal Register. Okay, like I said, generic can not be registered or lose registration. So if you were selling apples and you wanted to get a trademark for the Apple Shop as your trademark, your brand, that likely would be refused registration. Also, you have to police your trademark. So this is kind of a bummer. Once you go to the trouble and the cost of registering your trademark, you might expect that the USPTO is going to police your trademark. Unfortunately, you have to do that yourself. So you don't want to have your trademark become generic because it could lose trademark registration. And that's what happened with aspirin. Aspirin is really salicylic acid, and aspirin was a trademark, but because they didn't police it and everyone just started calling that little white pill for headaches aspirin, it's no longer a federal trademark because they didn't police it. Also, the elevator that moves you from floor to floor was a federal trademark, but because they didn't police it, it became generic, and that's what everyone calls it. Like in Europe, they call it a lift. In the US, they called it an elevator because that was the most well-known elevator company, and it lost distinctiveness after a while and is no longer a federal trademark. Okay. All right. So this is a screenshot of the trademark, the landing page at the USPTO, and this is where you're going to search for existing trademarks, apply for federal trademarks, and learn about the process. If you hover over the Find It Fast menu, over here, you'll find additional resources like this. Okay, so this is me hovering over the live one. You get to see this. The blue arrows point to the 3 areas to start your trademark search. The top one points to TESS, which is where you're going to search for existing trademarks. TESS is an acronym for Trademark Electronic Search System. Below is the TEAS interface where you're going to apply for filing your trademark right here. And the lowest arrow down here at the ID manual is where we're going to start first. The ID manual will help determine what goods and services your product or service is, and then it'll help you figure out how much you're going to pay. Okay.
Cheryl?
Yes.
There's another question.
Yes.
The client and her daughter have a registered trademark, but the services are now expanding. They want to know if there's an amendment to expand goods and services from the original trademark, or do they need to reapply?
That's a really good question. I think that, let me think about this. They have to apply for additional goods and services. And I think it might have to go through the examination process again to make sure there's not conflicting, and they would have to pay more. So there's a number at the end of the presentation to call to the USPTO and ask them, like, what do we have to do to add additional goods and services? If they're in a different class of goods and services, that's one thing. If they're just still within your same classification, you know, you might not have to reapply and spend more money. But the number will be at the end. Very good question.
Thank you.
Okay. All right. All right, so here is the ID manual. So you click on that, and you're going to type words in to describe your goods and services that you're selling. For this example, say I'm going to stop being a librarian and become a winemaker as my second career. I would like to call my wine brand Cabana Wine, and use a palm tree logo in combination with the word Cabana for my wine trademark. So here I've typed in wine for my goods. Okay, and when you're trying this, I would try different words or different combinations of words to locate the appropriate goods and services, because what you call it might not be necessarily what the USPTO calls it. So after I type in wine and press enter, I'm going to have this list. Okay, fortunately, wine is at the top of the list, and it's going to highlight wine that appears. Okay, I can see next to it, it's right at the top. If I hover over class 33 to the left of the word, I can see that class 33 is for wine and spirits, meaning alcoholic beverages except beer, and also alcoholic preparations for making beverages. If I also want to sell wine spritzers, which are down here at the bottom, I could do that under class 33 and not have to pay an extra fee. If I wanted to sell wine decanters, which is down here, I see that it's a different class than wine. It's class 21, so I would have to pay an additional fee for an additional class of goods and services. So, you know, so if I wanted to sell wine, it's class 33. The other things that are in the same class, red wine, mulled wine, Wine spritzers are all class 33. If I want to sell wine decanters or wine buckets with my trademark, it's a different class of goods and services and would cost more money. Okay.
And another question,
Sure.
what if your company is registered with the state and the federal government? Can someone else trademark your name?
Well, it depends on whether their trademark is similar and what they're selling. So they could actually use the exact same trademark if they were selling something completely different. So think about Acura, which is the exact same trademark, but it exists for 3 very different businesses: cars, selling pens, and selling lab equipment. So, but even if you're selling the related goods and services and it's similar in sound, appearance, and meaning, then the second person probably would not be able to. Okay, so it's based on what your trademark is, sound, appearance, and meaning, and goods and services. Okay.
Thank you.
All right. So after I figure out I'm selling wine, class 33, I'm going to go to tests and do start with a basic word mark search. So let me go back and show you again where that is. Okay, so USPTO.gov, hover over trademarks. And first I was looking at the ID manual. Now I'm going to go to tests, okay, to search for existing trademarks. Okay, basic word mark search is a good place to start. Okay, so what I'm going to do is I'm going to type in cabana and hit submit. So I see I get 506 records. That's a lot to look through. So you're going to see here that all of them have a serial number, and that means they're in process or an active trademark. They've, paid their money, they submitted the proper forms, and they're on their way. Okay. Things that have a registered trademark will have a number under registration. Okay. So it generally takes several months before the trademark examiner picks up your application. So it could be that they haven't gotten started on, they're in the process, they're waiting the results of an office action. The office action is when they have questions like, we have a question or a problem about your application for trademark, and you need to get back to us to answer our questions or resolve it under a certain period of time. So that's all these, and then they're the registered ones. So you're going to see over here, some are live and some are dead. If something is dead, it could be abandoned. They never got the trademark, like this one. They didn't follow through to registration. Sometimes they have been registered or they're dead because they didn't pay their renewal fee, which is due every 10 years. So every 10 years you have to fill out paperwork and pay more money and send us a picture of your good or a link to your working website, because they don't want people hanging on to trademarks if they're not actually using them. Okay, so if something is dead, it's technically available for use, but they could have common law trademark rights. Okay, so what does that mean? So say you want to use something and then you find that it's related goods and services, similar in sound, appearance, and meaning, but it's dead. So it's technically available to for registration on the federal level, but they could have common law trademark rights. And that means, say they're selling their product in a small town in New Mexico, okay, and their area isn't very big. So you wouldn't be able to go into that territory if they have common law trademark rights, but that might not matter to you. Like, okay, I can't sell in that one small area, I'm going to proceed. But what if they let their registration lapse, they didn't pay the money, they didn't want to take the time to go through the renewal process, but they're selling goods and services all over the southern United States? Then that means that you wouldn't be able to expand there, and you might have to think like, do I want to use this trademark that I have in mind when I would not be able to sell my goods and services throughout the southern US because they have trademark rights, okay? All right, so that's my first shot. I would say just type in the word in the basic search box, press submit and see what comes up, okay? All right, now remember I said sound, appearance, and meaning, so I should try different spellings of my word. So I could try cabana or cabana with a K because it looks different, but it sounds the same, cabana, cabana. Search it and I'll see it's jumped up a little bit, 512 records, okay? All right, so say I wanted to expand it more, not just cabana or cabana. What if I thought, oh, well, I should try anything that starts with any letter and ends in abana, because that could be sound, appearance, meaning. So what I could do is I could put a question mark for the first character, and that would search for abana starting with any letter. So you'll see that this has jumped up quite a bit, 750, and that's going to pick up things like Adabana, Homabana, Babana. So that's going to expand it and give me different possibilities of things that are related in sound, appearance, and meaning. Okay, but regardless of all this, it really only matters what they're selling because it's sound, appearance, and meaning and related goods and services. So I'm going to go to this next one and I'm going to add my abana search to wine with a square bracket, GS, meaning goods and services, square bracket. And that's going to take it all the way down to 18 records, which is much easier to search through, okay? So I can go through these and see, you know, here's a lot that use a cabana with the exact same spelling that are related to wine. And so I should take a look at these and see what they're selling and make a determination whether I think this might shoot down my application because it's sound, appearance, meaning for related goods and services. Okay, now what if you have a logo that you want to protect, okay? So you're going to go back to the basic search and do the design search code manual. So this is a place to look up design codes, okay? Okay, so if you click on that, you're going to come up something like this. So there's a search box. And I can type in palm tree because that's what I want to use with my cabana as my wine trademark. Press search, and you're going to have something like this. So they've gone through to pretty much every possible thing that you could put in a trademark and give it a numeric code to help you search. So I put in palm tree, and you'll see it's in the division of 0501, which is trees or bushes. Okay, which is a category of 5 plants. So 05 is plants, 01 is trees and bushes, and then you can see there's different codes for different things. So this one is for trees or bushes with a rounded shape, including deciduous trees. 05, 01, 03 is palm trees, which is exactly what I'm looking for. But you can see it goes through and gets very specific. Here's this one, 05, 01, 05, leafless trees and bushes. This one, stumps, fallen trees, and trees, trunks of trees without branches, and then fruit-bearing plants. So it gets very specific. But I wrote down 05, 01, 03 because palm trees is exactly what I'm searching for. So what I could do is combine my search with abana and palm tree. Okay, and I'm going to see that there's 31 records of something abana and palm trees, and I can look through those. But it could be anything like you know, urban cabana, which might be a company selling cabanas, which is not very different than wine. But you could go through and take a look. Okay, all right. But to combine them all to really narrow it in so I have fewer things to look for, I could do abana and wine as a goods and service and 05, 01, 03 in square bracket DC for design code and also square bracket on the other side. And it takes it all the way down to 2, okay? However, I do have to search more because if you remember, class 33 is alcoholic beverages except beer and preparations for making alcoholic beverages. So I'm going to want to search cabana or really other spellings of it and class 33, and that's an international class in square brackets, and I'm going to see what comes up. So there's 12 of them, okay? And I happen to know, whoops, that the one ending in 91 is going to be a problem for me. So if I click on it, I'm going to see this. Cabana, and it's spelled exactly the same. Their goods and services are distilled spirits made from sugar cane class 033, okay? Even though it's not wine, this is definitely a problem for cabana. And actually, this trademark has been referenced for other people who want to use it for wine as a reason why they couldn't get it. So they cite this trademark saying it's exactly the same. They're selling alcoholic beverages, so you cannot use cabana to sell your wine. That's a problem. As long as it's still active. If it's dead, then that might make a difference. So another thing is to search the class also and see what is in there. So it might not be a conflicting trademark in wine, but here it is, distilled spirits made from sugar cane. So when you're doing searching, don't be afraid, like no one's writing down what you wrote and you can make mistakes. And so I would recommend just getting in there and playing around with it, kind of getting used to how it works and, see what you come up with. If you end up using an attorney, then at least you can say, well, I did a search and I found these things, and you might save yourself a little bit of money because you're already sort of familiar with the process. Okay. All right, so this, we're going to talk a little bit about foreign trademarks. Trademarks are territorial, and unfortunately, there's no international trademarks. If you want to get a foreign trademark protection, you can do it through a cooperative program, like the Madrid Protocol. That has 109 countries that belong to the treaty. So treaties like these are, the countries get together and make agreements to make life easier for each other. And this one, through commerce. And this is a little calculator where you can determine approximately how much it's going to cost. Also, the European Union has banded together, which has 27 countries now. And it's a cooperative program to make applying to EU companies cheaper and easier than applying to them separately. Because of Brexit, you do have to apply to the UK separately. Treaties provide certain minimums of protection, such as you will be treated the same way as any citizen of that country in terms of your application, and they will honor each other's filing dates within certain limits. Okay, if you're only going to apply for a few countries for a trademark, you can apply to individual countries under the Paris Convention. One of the main things that they're going to be doing when you file for a foreign trademark is they're going to check and make sure that your trademark doesn't mean something offensive or untoward in their language. One example that's often used is the US car from Chevrolet with the trademark Nova. This is a car from the 70s and 80s. Some of you who are older might remember it. My dad had one. Unfortunately, Nova in Spanish-speaking countries means it doesn't go, which is an unfortunate name for a car because no one wants a car that doesn't go. Another thing to remember about other countries is they might not require use in commerce like the United States does. So this can be a problem because if your product becomes very successful in the United States, people in a foreign country where use in commerce is not required may register and gain rights over the use of the name that you might be wanting to use in a foreign country. And you might have to pay them, and maybe pay them quite a bit, to get rights to use that trademark or find a different trademark to use. Also, you may be required to hire a local attorney for foreign trademarks. Usually, if you talk to a US attorney, they can recommend an attorney in a foreign country that they have worked with, okay? So use in commerce in the US keeps people from hoarding trademarks, because you know, you have to actually be using it, you have to actually be selling something across state lines, and that's the requirement of in commerce. You have to be selling or shipping your product across state lines, and in the time of the internet, that's much easier. And also provide a specimen, okay? So you actually have to be using it. Other countries don't require that. They just do kind of a cursory check to find out that it's not like a swear word or something untoward in their language, and then they would just give it out. And so you might have to pay someone to use that trademark, or you might have to come up with a different trademark for the same product. So an example of this same product, different trademarks in different countries, is Lay's potato chips in the US and Walker's crisp in the UK. Okay, so here's a picture of it. So these in the UK are Walker's chips, but these are really Lay's potato chips as we know them. So it's the same thing, but a different trademark in a different country, okay? And I think that there's a likelihood of confusion with using Lay's, and so in the UK, they decided to call them Walkers. Here's two others. Does anybody want to guess what this is? Okay, I'll tell you, it's Burger King, but in Australia, they call it Hungry Jack's, okay? And you can get a brekkie, which I think means breakfast, for $4.95 in Australian dollars at Hungry Jack's, okay? Here's another one. This is, we know it as Mr. Clean, but in Germany, it's known as Meister Proper, okay? Looks exactly the same, the packaging is the same guy in the white shirt with the bald head, but it's Meister Proper. So I think that's kind of fun. So there's a lot like that, that for whatever reason, they don't or can't use the same trademark we use in the US, so it's known by something else, even though it's exactly the same. So these are a map of all the countries that follow the Madrid Protocol. They're in green, so you see it's very many countries. The yellow is a different treaty for African countries. So using the Madrid Protocol can save you money. It's kind of like a highway, and could save you money applying for an international trademark. These are the countries that follow the Paris Convention that you could apply to if you want to apply to individual countries. So even though going through the treaty might save money if you want to apply to a bunch of different countries for your trademarks, if you only want to apply for one or two countries, using the Paris Convention might be cheaper. If you want to search for foreign trademarks, because tests will only tell you about US trademarks, you can go to these foreign trademarks searching at the Global Brand Database from the World Intellectual Property Organization, or WIPO as they call it. It's an agency of the United Nations. They have more than 44 million trademark and brand documentations from 55 jurisdictions. Okay. Design View is for the European Union. That's their central searching. And this is another one from the European Union. It's TM View with free trademark searches. So these are all free, that are freely available on the internet for you to search. Okay.
Cheryl, we have another question that came through.
Yeah.
Is there a difference from trademark, or is there a difference between trademark and copyright?
Yes. So trademark is for your business brand, or logo or slogan. It identifies your business. So it's a business identifier. Copyrights are more for things like you wrote a book, you made a movie, you have a blog, you take really cool photographs and you don't want other people ripping you off without paying for them. Sculpture, movies or audio, songs that you wrote. So our copyrights are for creations, more like artistic creations, and trademarks are a source identifier. They identify the company that's selling them.
Great.
Okay. So, if you wrote a book, you would get a copyright. You couldn't get a trademark on one book title. And that's why if you go to Amazon, somebody told you the name of a good book and you type in the words and you see there's 3 different books with the exact same titles, and you're like, well, that's crazy. How am I supposed to know which one to buy? So you have to read the blurb. But if you write a book series, you can get a trademark. Okay. So trademark for a book series, copyright for the book itself.
Thank you.
Yes, good question. All right, so we need to talk about business names, trademarks, and domain names. So they're not necessarily the same, and that's why you have does not equal sign. They come from different agencies. A business name is registered with a state agency, such as the Pennsylvania Department of State. Trademarks are registered either with a state trademark agency or the USPTO. And domain names are registered with an accredited domain name registrar like GoDaddy or domain.com. So if you have purchased or thinking about purchasing a domain name, you should check and make sure that it's not a registered trademark for another entity. Because even though you bought it, you can say, well, I bought it, I paid for it. Someone else might have trademark rights on it. So you should be aware of that. Okay. Unfortunately, I have to talk a little bit about scams. The USPTO advises to always check out the reputation of invention promoters or any requests for money for patents or trademarks. Be aware that the requests for fees for patents and trademarks will only come from the USPTO in Alexandria, Virginia, or a state agency for trademarks. Unscrupulous people might try to take advantage of you and either charge you a lot of money for things you could easily do yourself for free. They could outright steal your money or not get you the type of IP that will be most useful to you, okay? So you should check out their reputations of, anyone says, well, I'll get you a trademark, cheap and easy or something, and always check it out before, you put down any money. Because let me go back and I'm going to show you, all right, this. So once you apply and you've paid your money and you got your registration number, this is going to appear, okay? It's going to say who is the registrant. It's going to have names. It's going to have an address, okay, and information about you. So people can go on here and look at this and like, oh, okay, here's their address. I'm going to send them a letter and say, we want to help you. If you pay us X amount of money, we'll, expedite your trademark application. Or they could be just out and out trying to steal money. And this happens all the time. I get people calling me saying, I got this letter from someone and they said my trademark application is going to go dead if I don't send $500 to some post office box in Maine. Okay. You're never going to have to send money to anyone other than the state agency or the USPTO in Alexandria, Virginia. So unfortunately, it happens a lot. So please be very careful. I mean, some of them, they have names that look like they're the USPTO. or the PTRC, Patent and Trademark Resource Center, but you know, unless it's going to Alexandria, Virginia, or the state agency, they're trying to rip you off. Okay, let me go back here. All right, so do you need a lawyer? You can do this yourself. It's strictly up to you. About 60 to 70% of people who apply for federal trademarks use an attorney, but that means 30 to 40% don't. So you can, so it's like about half, a little less than half do it themselves. It's certainly doable. You want to, if you want to get an attorney, you could go to the local bar association, like say in Philadelphia, I could go to the Philadelphia Bar Association and get a list of people who could help me obtain a federal trademark. You could ask friends, but using an attorney makes things easier. They're going to do the search and handle all the paperwork and respond to office actions. Office actions are, like I said, if they have a question or a problem with your application, an attorney will respond to that. But they are expensive. It's probably going to be several $1,000s for a trademark attorney, but you know, it's up to you how you want to handle it. If you want to use an attorney, but you don't have the money just laying around, which is understandable, there's places where you can get help. It's not exhausted, but just here's an idea. Here's Philadelphia VIP. Here's their web address. However, the business must be within Philadelphia, but a lot of people, they're a partner organization. They have attorneys that will do it for free. They do want you to have an LLC or be incorporated, but if you're not there yet, they will help you to become so. So you would still have to pay the fees to the USPTO or any fees for registering your business, but they will do the legal help for free. Also, the University of Pennsylvania Law School has clinics 4 times a year at the library. We just had one last night where, and we'll have more in the spring where you can register and get 45 minutes for free with law school students and their professor to ask questions about intellectual property. Also, they take clients on twice a year. So every August and January, you can apply to them following this link and ask to become a client. So it won't just be like the 45 minutes, you actually become a client of theirs, and they will help you with your intellectual property. Okay, so if you're interested in that, check out late in December or beginning in January and apply for that. Also, there's other law schools clinics that are authorized by the USPTO, and you can click to find it. Now, some of these, which are around the country, only focus in one geographic area, like the University of Pennsylvania Law School only takes clients in Pennsylvania, and other ones are like that. But some of these law school clinics throughout the US take anybody. You know, you don't have to be living within their district. They will take anybody. So it's you know, worth taking a look and reaching out to them if you're interested in getting free legal help. Okay. And like I said, we also have office hours. We just had it last night for the Penn Law School, and they're going to do it again. I think it's going to be in March and April. So they do it 4 times a year, March and April, October, November. Okay. So here are even more links than, you know, that we already have. And if you're don't see a link for something you're interested, you can let me know. And I'm ready for more questions. Ask anything. We have time, and no question is silly, so I'm here.
All right, we do have another question. This person writes in many different genres and often contributes original inspirational thoughts to various social media platforms like Instagram, TikTok, Facebook, and wants to know if it's wise to place your copyright somewhere on your work when posting.
That's a great idea, because actually copyright is protected once you put it down in tangible form. So by putting on the website, it automatically has copyright protection. But to be extra safe, you can put a copyright notice, and if you just give me a second, I'll find it. So put a copyright notice on it, so people can't say, oh my gosh, I had no idea this was copyrighted, because you're going to put your copyright notice on there. So like, yeah, this is copyrighted, so please don't even think about using this without getting permission from me. And also you can take the extra step of applying for a copyright registration at copyright.gov. If you want to file a lawsuit, that's required if you want to file suit. But copyright exists at the moment of you put it in tangible form. Okay, so if you just give me a second, I'm going to try to find that another thing, and I can show you a little bit about that. This will take me a second. Okay, this is another one. I did this class last month for you. Okay. All right, so this is about copyrights. They're easier to get. To get a trademark, a federal trademark, takes about 9 months to a year. Copyright is quicker, 3 to 9 months to receive. It's $45 and up. And protection is longer. It's the life of the author plus 75 years. This is what it covers. This is the definition. It's granted for original works of authorship fixed in a tangible medium of expression. Covers both published and unpublished works. So original work of authorship is a work that's independently created by a human author, so it can't be something by a machine, at least not US, and possesses at least some minimum degree of creativity. So that doesn't mean like a list of things. Things that are lists cannot be copyrighted. So that's like the phone book couldn't be copyrighted. Also, everyone asks like, okay, my apple pie recipe, I want to copyright that. A mere listing of ingredients will not qualify for copyright. If you write a whole cookbook, that can be protected by copyright, but not just a listing of ingredients like a recipe for lemon bread. Okay, here's some example of fixed and a tangible medium of expression, and putting it in print or a computer file or publishing on the web is a tangible medium of expression. And here's the copyright notice. It's a great idea to put this on your work. This is the generally accepted form of copyright notation. It's a C in the circle, the year of creation, and your name. Okay, and that's copyright notation. That's a good idea to use. Okay. Anything else?
A couple more questions have come through. First one, my daughter and I have registered trademark listed under our names, but recently established a new LLC in Pennsylvania. We feel it's safer to move ownership of our trademark under the company name and are looking at assigning our trademark, but will that affect our nationwide use of the service?
You know, I don't know enough to be able to tell you, and that sounds like kind of a legal question that I can't answer. So I would go, and I'm going to go back to the our presentation, and ask and suggest that you contact this number, the USPTO Trademark Assistance Center. This is the number. They can't give legal advice, but they could give you technical answers like, okay, we want to expand our product line to a different class of goods and services. What is the process for that? And they can talk about the process of changing the owner name. And they can give you good answers. They can't tell you, should you do that? Because they can't give legal advice, but they can give you good technical answers to questions like that.
Okay. The next question that came in, is it also wise to have a disclosure statement listed on your website?
I'm not sure what that means.
Okay.
A disclosure, I'm not really sure what that means, so I can't really give an answer.
Okay. And looks like there's two more.
Okay.
I've noticed a lot of businesses' websites are copyrighted. What exactly should they be copywriting, and is that necessary?
They can do a blanket copyright, and put on the year of creation, and you have copyright rights then at the fixed and tangible form put on your website. You have copyright rights. However, if you want to, you can register. So like maybe once a year or once every 6 months or once every month, however you want, you can go to the Copyright Office, copyright.gov, and actually register your copyright for that. And that was, if you want to sue someone, you have to have a registration, but you have copyright rights. If you fulfill the definition of copyright at the minute it's fixed in tangible form and it has some minimum degree of creativity, you have copyright rights then. And then as an added measure, it's a good idea to put the copyright notice on there to let them know, don't even think about using this without my permission.
Okay. And the last question, it looks like, are there any specific requirements for a website in order for it to be considered demonstrating commercial use? I imagine the average sales marketing page would be sufficient, but is there anything in particular that you would recommend to help an application get through smoothly?
So does this relate to trademarks?
It does not say, but let's see here.
So
yes, trademarks, yes.
Okay, so you can get something called an intent to use application. So it's good for up to 3 years. And every 6 months, they're going to ask you, do you have a specimen to show us of use in commerce? Are you using it in commerce, and what's the specimen? So you need to be selling or shipping your product across state lines, and that's in commerce. And you also have to be actually selling something, okay? So if you're not ready, they'll say, okay, we'll give you another 6 months and now pay us, I think it's $150. Then in 6 months, they're gonna ask you again, are you yet ready? And if you're not, another $150, up to 3 years, because they don't want people hoarding trademarks. They want them actively to be in use. So for the use in commerce, you have to be selling or shipping across state lines, and you have to have a specimen. So if your goods and services are services, it has to be a link to a working website. So you have to show them that here's our website. It's actually active. People are buying. You can click on this, and you'll get services or goods and pay for them. Or if you're selling goods like shoes, like say my ketchup for my sneaker brand, I would send them a picture of my sneaker with the label inside, showing that it's actually a thing. Okay, selling, shipping across state lines, and have a specimen like a picture of the product or a working website. They do, sometimes people try to slide by doing a Photoshop thing. They're pretty good about catching that. So it has to be working, you have to be selling stuff across state lines, and then you can qualify. So they don't want to see a link to a website that says in construction. It has to be actually have to be a going concern.
Okay. One quick question, and this one just came through. Would a company profile on LinkedIn suffice instead of a website?
You have to actually be selling something.
Yeah.
You have to be selling something. So you could have like a picture of your store with the goods inside, a picture of your goods, what you're selling, a link to the working website where people buy stuff and pay money for it. You know, or actually, like somebody asked me once, a nonprofit, they weren't actually selling something, but they had services. Okay.
Okay. So I don't see any more open questions at this time. So
Good questions all. You know, if you want to have a one-on-one, and that's when I meet you on Zoom just like this, and you know, I kind of go into more detail on the website and demonstrate searching for your trademark. Now I can't legally search for your exact trademark, but I can do a sample search and kind of get in more detail about searching on the website. We have other classes. I'm going to be coming back to you next month in December for a patents one-on-one presentation. So, and we have other classes and programs here. We have classes too at the library. You can click on this and go to and see what we have coming up. If you're near Philadelphia, we do have a cool thing. So on Thursday, twice a month on Thursdays at 1 o'clock from 1 to 3, we have free headshots. If you're interested, might be worth a trip. We have a grant for a professional photographer, and he'll take free headshots for you, and then you can get them within 2 weeks. And you know, headshots, a professional headshot can cost a couple $100. So that's something that we have. You can go to freelibrary.org/BRIC, BRIC. And see when it is. You don't have to register, you can just show up, but don't show up in the last 15 minutes because they won't have enough time to, you know, finish the session. So I hope to see you again, maybe next month, or come to one of our programs at the library, or register for a one-on-one. You guys have been great. You've had great questions, and I thank you so much for coming.
all right. And thank you everyone for attending today's seminar. The slides and the recordings will be sent out to everyone, so please feel free to utilize our services. And I appreciate everyone coming today. And thank you very much, Cheryl, for all your information.
All right, thank you so much. It's been a pleasure being there.
All
Bye-bye.
right. Have a great day, everyone. Thank you.
Thank you.